Next on Newsmax Prime, fashion and the First Amendment. The Supreme Court rules against Abercrombie & Fitch in favor of a young Muslim woman. We'll talk about it with Alan Dershowitz. Also ahead, a closer look at Dr. Ben Carson. He may not be a politician, but he's having some success in presidential politics. John Funn joins us with his assessment. And letters matter to Numbers USA. That border security group will give letter grades to the candidates throughout the 2016 presidential campaign. We'll take a look at who ranks where at this early stage of the race. Newsmax Prime starts now. Good evening and welcome to the Monday edition of Newsmax Prime. I'm J.D. Hayworth, and there are two stories of prime interest tonight. The Supreme Court ruling in favor of a Muslim woman who was denied a job at a clothing store in Oklahoma because she wore a headscarf for religious purposes. More on that in a moment. But first, national security concerns abound as the Senate debate yields no compromise, allowing some provisions of the Patriot Act to expire, at least temporarily. Miranda Kahn has the latest from our newsroom. Miranda?
JD, for the first time in 14 years, federal agents will have to subpoena phone companies for calling records and then wait for a response, slowing down the time it will take for officials to identify potential terror threats, thanks to the Senate allowing key provisions of the Patriot Act to expire. Kentucky Senator Rand Paul, an outspoken critic of the NSA program, was on TV earlier calling this a big victory for privacy advocates. Meanwhile, newly declared presidential candidate Lindsey Graham took aim at Senator Paul and others, pushing back against the Patriot Act during the announcement he made this morning in South Carolina.
The Obama administration and some of my colleagues in Congress have substituted wishful thinking for sound national security strategy.
Senator Paul said today he is fighting because he wants more collection of records on terrorists, but less collection on innocent Americans. Now, many people believe if the NSA is unable to collect data, if and when a new terrorist threat surfaces, even for only a short time, our national security will be put at even greater risk. This debate will continue in Washington tomorrow. JD?
Thanks, Miranda. With more on the story, we're pleased to be joined by Harvard Law professor and Newsmax blogger Alan Dershowitz. Alan, of course, also the author of Terror Tunnels, the case for Israel's just war against Hamas. And joining us from Newsmax Washington, my former colleague, Michael Patrick Flanagan. And I'm not allergic to either of you gentlemen. I just sneezed there a little bit. Thanks for being here with me tonight. I will carry on. It wasn't a sneeze, it wasn't a snicker, but it is a lapse in provisions of the Patriot Act. Alan, what are the legal implications of what we saw by the Senate in action?
Well, it's going to be harder to get warrants. It's going to be more difficult to trace people who use different cell phones if the cell phone provision isn't renewed. Lone wolf terrorists will have an easier time. We need a compromise, obviously. I think most Americans feel that the NSA went too far, but they also feel that we have to empower the NSA to prevent terrorism and protect us. So we need to put politics aside, and we need to stop being strident and polemical about this and come to some reasonable solution that affords us maximum safety consistent with liberty.
Mike, you heard Alan mention a compromise. Seems like the House had come up with that type of compromise with its bill. But there is Rand Paul using the rules of the Senate to make clear his disdain for any renewal of any sort of Patriot Act. What does this mean both in terms of public policy and our national security? And yes, we might as well bring it up, presidential politics for Rand Paul.
Well, I think it increases Rand Paul's stock, to answer your last question first. But I agree with Professor Dershowitz, is that the Patriot Act came in to find bad guys and to allow certain otherwise transgressions of our liberties to go ahead and find the bad guys. Unfortunately, predicate in that act, in the act you voted for, JT, while you were there, was the fact that we assumed the executive would behave rationally and in the interests of privacy. And as all bureaucracies do under Bush and then later Obama too, they went nuts, and they decided they could collect every bit of information on earth they could. And going that far, they have to be yanked back. And so it's going to take more than a mere compromise by the House. It's going to take the pendulum to swing in the other direction for a while until we can lay out in no uncertain terms some parameters of the NSA's ability to acquire information.
This is so typical America. Our pendulum swing very wide. I mean, we went too far after 9/11, and now it seems like we're going too far in the other direction. Certainly Rand Paul seems to be going too far. And we have to stop these wide swings because they neither protect liberty nor do they protect us from terrorism. We need to have a centrist compromise that looks at the really important issues of privacy and the really important needs that the NSA has in tracking down terrorists and strike an appropriate compromise.
Now, let us turn from the Patriot Act to a decision handed down today by the Supreme Court. Pretty convincing decision, 8-1 vote. The court handing a victory to the U.S. Equal Opportunity Employment Commission, who sued on behalf of the young Muslim woman who was concerned about the fact she was not hired by Abercrombie & Fitch out in Oklahoma. Alan, your take on the High Court's decision?
Well, I'll start with a very funny story. When I was a law clerk 50 years ago or more, Justice Goldberg called me and said, do Orthodox Jewish women have to wear a hat? Because there's a woman arguing in front of us who's wearing a hat. And the Supreme Court rules prohibit hats in the Supreme Court. And I wrote back and said, yes, Orthodox Jewish women have to wear a hat. And he wrote back, but does it have to be a really big, ugly hat? And I said, no. And he asked me to call her into chambers. And we called this woman into chambers. She's now a distinguished professor at Cardozo Law School, and said, you can wear a hat, but next time, make it a little more stylish, a little bit more discreet. And, you know, that's what Abercrombie & Fitch wanted. They wanted style, but, you know, obviously the law trumps style, and it was clearly the right decision. Our country accommodates religion. We're not France. France says, oh, no, 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 we're not going to let you wear your head covered or anything like that or any other religious symbols. We strike an appropriate balance. Obviously, we're not going to let Muslim women take their driver's license pictures, which are identification, with only a slit for their eyes, because that would interfere with identification. But when it comes to a job in a fashion place, of course, the law has to trump style.
What about it, Michael Flanagan?
I'm on the back end of agreement today. I just agree with everything. I think Professor Dershowitz is exactly correct. We make accommodations for religion, and this is something maybe the gay lobby needs to focus on a little bit now and find out that where your rights begin, other people's rights end, and that gray area in between is a time-tried area of compromise and work. And I think we all have to learn to live together a little nicer. And if somebody has objection to baking your cake or has objection to you not wearing the scarf, well, maybe they need to all get over it and let you practice your religion the way it needs to be. Although I have one larger question is, why is someone who takes their very conservative religion so seriously hanging out in Abercrombie & Fitch? That's another matter entirely. But
yeah, and
that aside, I agree. Good decision.
Yeah, the court didn't go into that. Minute 30 remains. Let's go back to a case we talked about, Alan, on Friday. That is the situation involving former House Speaker Dennis Hastert, indicted on charges of lying to the FBI about why he withdrew large sums of money believed to be a payoff for a man who was possibly blackmailing him. Alan, you said, and I quote, "This case smells." Has anything happened over the weekend to change your opinion?
No, it's even worse, I think, because, obviously it was the government that leaked the story of what was behind the story, these allegations of sexual impropriety. This is just not the business of the federal government. Even the lying, I don't think the lying was material, because I don't think the federal government has a right to know that somebody's paying hush money to try to prevent the media from learning about a private act whose statute of limitations has long ago expired. This is a state matter. It should be prosecuted by the states. Most states have statute of limitations, and I think this is an overreaching by federal prosecutors.
Final 15 seconds to you, Michael.
I'll tell you, the blackmail statute that was offended here is not common law blackmail or even state statute. This is a federal blackmail statute, and it has enormous and frighteningly huge penalties. And for the U.S. Attorney to just blithely put that aside and say, we're going to go after some predicate offense represented in these banking issues is really problematic.
Gentlemen, we thank you both for your perspective, and Newsmax Prime will continue.